Assembling a winning team. A startup team starts out with the founders. As the company grows, a CEO and executive officers are appointed. A board of directors is assembled, and many high-tech startups also create a board of advisors. Professional advisors such as attorneys and accountants are engaged and play an important role in Silicon Valley-style startup ventures. Shareholders, such as venture capital investors, are usually active members of the startup team. Employees and independent contractors are hired, and many of the tasks are often outsourced to outside agencies. As there are so few team members in a startup, selection of the team is critical if the business is going to generate momentum and achieve success. Some startups are designed for world domination and aim to quickly achieve critical mass, such that they are able to sell shares to the public via an initial public offering and subsequent public offerings. These ventures need to assemble relatively large teams with armies of sales and marketing staff, so they're able to generate significant momentum in the marketplace. Assembling a large team is expensive, and for startup ventures usually requires several rounds of venture capital funding. Each round of funding dilutes the ownership of the founders. Instead of building huge corporations, many startups in the technology sector focus on building compelling new products that will become appealing acquisition targets for corporations in search of new products and revenue streams. Small, nimble, product development-oriented teams are often more suitable for a venture aiming for a short sprint to technology or asset sale, and larger, sales-oriented teams are required for the long haul to IPO. Of course, every new startup starts life with a founding entrepreneur or a team of co-founders. If you're the entrepreneur, when you start a new business, you have to decide whether you want to go it alone or bring in partners. It's natural to feel more exposed and vulnerable when you go it alone, but bringing in partners needs to be carefully thought through and can easily destroy the business. It can be very tempting to invite your buddies to join your startup. Inviting them in before the company has any momentum, however, can be very costly to you. Don't be surprised if they ask for equal partnerships. Equal partnerships are never exactly equal. Two partners may have the same stock options and remuneration packages, but it's impossible for two people to make precisely the same level of contribution. One partner is sure to take more responsibility and pull more weight than the other. How would you feel if you were working 80 hours a week while your equal partner was sipping gin and tonics on the beach? It can happen. Sometimes collaboration sparks ideas and releases untapped talents. In some cases, co-founders are effective at growing the business, but in other cases, the company has a better chance of survival when it has a single, strong founder to lead the way. If you're the founder of a new startup and you really can't make it a success without bringing in a collaborator, timing is important, and you might want to generate some momentum on your own first, then you can bring in your collaborators without giving away the farm. If it's your baby and they know it, you'll be able to negotiate reasonable terms. Here are some tips for founding entrepreneurs. Go it alone as long as you possibly can before you bring in a partner. At least write the business plan, hire the lawyers and form the company. It's a good idea to have the lawyers help you negotiate the terms with your partners. Make it clear who's in charge and agree on the business plan up front. You need everyone pulling together in the same direction from the very start. Don't give your co-founders, your partners, a share of the business up front. Reward them with stock options that vest over 3 or 4 years. If it doesn't work out, you'll be in a position to part company without losing half the business. And finally, protect the intellectual property with an employment contract that assigns ownership of the patents and the intellectual property to the company. Some people are suitable for startup life and some are not. Some team members will help generate momentum and some will not. A startup has fewer staff, and due to the lack of finance and lack of credibility, a startup usually has more challenges than a larger organization. Multi-talented individuals able to handle many different types of tasks are suitable for startup ventures. These can be energetic, open-minded newbies or battle-scarred business veterans. The ability to generate momentum and create a positive buzz around the company and its products are valuable characteristics to look for when hiring a startup team. On the other hand, specialists that might focus on a small aspect of the business might be suitable for employment in a large corporation, but are not very useful in a small startup. When recruiting for a startup, it's also important to avoid individuals requiring large budgets and individuals reliant on assistants and support staff. Budgets and staff are usually in very short supply or non-existent in a startup venture. Some of the skills most critical for a startup are enthusiasm, adaptability, and perseverance. The ability and determination to keep going when the going gets tough are critical to startup success. Both enthusiasm and despondency are contagious. Each individual has an impact on company momentum, and this is especially true in a small startup. A person with a results-oriented, upbeat attitude can assist in the achievement of milestones and contribute to team morale. They can also help create a buzz around the company. Positive momentum generators can have a magical effect on a startup. On the flip side, negative attitudes and individuals spreading doom and gloom around the company are a menace to be avoided at all costs. When organizing a team for a startup or any business venture, it's important to understand the laws of agency. An agent is a person who acts on behalf of another, the principal, and is able to represent the principal in dealings with a third party. A startup and any company involves a chain of agency. The board of directors act as agents for the shareholders, and the CEO acts as an agent for the board of directors. The CEO acts as an agent for the company and so is empowered to sign contracts on behalf of the company. One important thing to remember about agency is that the agent is able to bind the principal to contracts and commitments, so long as the commitments are within the scope of the agency. The CEO's scope of agency to represent the company extends to virtually all the day-to-day operations of the company. There are some decisions that are beyond the scope of the CEO's agency duties, such as a decision to change the core business strategy, and these decisions must be referred to the board of directors. The board of directors, acting as a whole, has agency powers to make virtually all decisions on behalf of the company. But there are some decisions that are even beyond the scope of the agency powers of the board of directors. A decision to sell all or substantially all the company's assets is beyond the scope of the board's agency powers, and this decision needs to be made by the shareholders themselves. An agency is usually created when the principal communicates with a third party and confirms that the agent has powers to act on the principal's behalf. So an agency is created when Wilma says to Barney, "I'm interested in buying your car, but I'm out of town for a few weeks, and I'll send Fred to meet with you to negotiate the deal on my behalf. I'm happy to go ahead and purchase the car on whatever price and terms you agree with Fred." In this scenario, Wilma is the principal and Fred is Wilma's agent. Fred is acting on Wilma's behalf when Fred negotiates the deal with Barney. In a company, this type of express agency could be created when the company secretary sends an official letter to a real estate company saying that the CEO, Jim Jones, has authority to represent the company in negotiating a lease. However, as Jim Jones is the CEO, and it's customary for the CEO to have powers to sign leases on behalf of the company, Jim's agency powers can be implied. A court would usually confirm that a lease signed by the CEO on behalf of the company actually binds that company to the terms of the lease. If the lease was signed by Alex Johnson, the marketing manager, without some communication from the CEO or the company secretary that Alex Johnson has powers to sign leases, then the company could deny that it is bound by the terms of the lease, because Alex Johnson did not have the agency powers to act for the company when it came to leases. Alex might be an agent for the company when it comes to buying advertising space, but as marketing manager, Alex does not have implied powers to act for the company in regard to real estate leases. Who holds the power in a startup organization? What are the sources of authority? In the United States, companies are creatures of state law. They are created by the state and governed by state corporate law, but in some cases, state law can be trumped by federal law, in areas where the US Constitution has assigned powers to the federal government. A typical Silicon Valley-style startup is created as a Delaware C corporation. As you will hear in other courses, venture capital investors and lawyers in Silicon Valley and the high-tech sector are accustomed to Delaware state law and usually prefer to have companies organized as Delaware corporations. So Delaware state law usually decides disputes involving shareholders, directors, officers, and employees of high-tech startups. The company has its own form of constitution in the form of its articles of association and its bylaws. These documents are adopted by the shareholders and directors, usually when the company is formed, and once again, venture capital investors usually require the articles and bylaws to be formed in a familiar cookie-cutter style. The articles and bylaws define how shares are structured in the company, and directors and officers are hired and fired. Now, you would usually expect the board of directors to be elected by a majority of the holders of common stock. This is not exactly the case in a Silicon Valley-style startup, as the investors are issued with preferred stock, and preferred stockholders have special powers to elect their own directors. Usually, the venture capital investors, through their preferred stock, get to elect 2 or more directors, and the common stockholders, the founders and employees, usually get to elect 1 director to the board. Through these preferred stock voting rights, the investors usually take control of the board of directors and get to elect the CEO. The CEO is appointed by the board of directors and can be replaced by the board of directors. The CEO appoints the other officers and can assemble a board of advisors. Like the chain of agency, the chain of powers extends up from the CEO to the board of directors to the shareholders, and the preferred stockholders have special powers provided to them by the company bylaws and supported by state and federal laws. The Chief Executive Officer is the most senior officer in the company and reports to the board of directors. When you form a Delaware corporation, you're required to appoint a president. There's no requirement to designate the president as CEO, but the president can act as CEO, or you could appoint a CEO and a president. If you do, the CEO is assumed to hold a more senior position than the president. It's the most senior officer. In limited companies in the UK and other countries where UK-derived law controls, the most senior officer is usually called the managing director. Again, the managing director can act as CEO. Although the CEO often sits on the board of directors, it's not necessary, and many CEOs do not hold board seats. The CEO is responsible for the day-to-day operations of the business and acts as an agent for the board of directors. Unusual decisions outside the scope of the day-to-day operations of the business usually have to be deferred to the board. In startup ventures, the first CEO is often the founder or one of the founders. It's not unusual for a career CEO then to be appointed when the company raises its first round of venture capital funding, and the venture capital investors are usually involved in the selection and appointment of the incoming CEO. The management team, sometimes referred to as the executive committee, reports to the CEO. Delaware corporation law requires a president, treasurer, secretary, and at least one director. However, in Delaware, one person can fulfill all these roles. The executive committee develops as the company grows and can comprise several C-level officers, including the chief financial officer, chief operating officer, and others. Members of the management team are usually engaged as employees and compensated with a combination of salary and stock options. The board of directors reports to the shareholders and is responsible for running the company. It's usually held accountable for the company in law, hence there are liabilities attached to sitting on a board of directors. You'll find that the duties, responsibilities and liabilities associated with being a member of the board of directors are covered in detail in other lectures and other Silicon Valley Business School courses, especially the course on business organizations. An inside director works inside the company, usually as CEO, CFO, founder, or in some other executive position. Outside directors usually work in other companies and bring outside perspectives. In a high-tech startup, the first outside directors are usually venture capital investors and holders of preferred stock. In a high-tech startup, the inside directors are usually employees compensated with stock options and salary. The outside directors are usually venture capital investors who have a large financial stake in the company and do not require any compensation beyond their holdings of preferred stock. When the board grows and other outside directors are engaged, they are usually compensated with a combination of cash and stock. This is when the company has cash in the bank and is looking to recruit marquee names to the board. Of course, the company covers the expenses incurred by the director when attending board meetings. In larger companies, board panels can be appointed comprising subsets of directors to investigate specific matters and undertake specific tasks. For example, it would not be unusual for a company with a board comprising 5 directors to elect 2 members of the board to lead the recruitment of a new CEO. Another example would be a board panel assigned the task of leading the financial audits. No single member of the board has powers to make any decisions on behalf of the company. The board acts as a whole. Usually the whole board must agree to a resolution in order for that decision to be binding on the company. In normal circumstances, if the board consists of 5 members and 3 voted in favour of a resolution, then that resolution would be passed. So what happens if only 2 members of the board actually attend the board meeting? Well, usually the company bylaws define how many directors must attend the board meeting in order for decisions to be made. This is known as a quorum. If the quorum is 3 and the board meeting is attended by only 2 members of the board, then the quorum requirement will not be met and the decisions made at the meeting will not be valid. Note, in Delaware corporate law, a director can attend a meeting remotely, so attending by phone is quite common. It's not necessary to have all the board members in the same room in order to meet the quorum requirements in a Delaware corporation. As the board of directors is held accountable for the company, it's a responsible position and members of the board can be exposed to liabilities. More information on this is available in other lectures and other courses, but it's not unusual for outside directors to request indemnification from the company and/or require directors and officers insurance before they take a board seat. Directors and officers insurance is available, but the insurers demand certain requirements, such as having an employee handbook issued to all employees, and these requirements and the associated costs usually mean that startups go without directors and officers insurance in the company's formative years. A high-tech startup usually starts out as a Delaware corporation with one single member of the board of directors. The initial sole director is usually the founder. To avoid deadlock in voting, a board of directors usually has an odd number of members. It's not very likely for deadlock to occur when the board consists of 1, 3, or 5 directors. Upon raising the first round of venture capital financing, the lead venture capital investor usually takes a seat on the board. The venture capital investor ordinarily wishes to take control of the board, so a third board seat is allocated, and if the VC wishes to appoint a new CEO, this third seat often goes to the CEO. If the founder remains on as CEO, this third seat is usually allocated to someone representing the venture capital firm. As the venture investors will likely require control of a board with 3 seats in the early stage, startup entrepreneurs that formed with a 3-person board earlier on and allocated seats to several founders instead of just one will usually find that these additional members of the board of directors will be required to give up their seats when the venture capital investment comes in and the venture firm takes control. In the expansion stage, when funding from a strategic investor is raised, that strategic investor usually takes a 4th seat on the board. 4 is not an odd number, so a 5th seat is allocated to an outside director to avoid deadlock in voting. This is often the first time a high-tech startup has appointed an outside director. Outside directors are more likely to ask for directors and officers insurance and indemnification from the company in order to mitigate any liabilities the director could incur as a result of the appointment. When the company enters the mezzanine stage and is preparing for an initial public offering, additional seats are usually created on the board and allocated to marquee names. These are high-profile individuals that are familiar to Wall Street investors and that have proved to be reliable and responsible in directing publicly traded companies in the past. Shareholders own the company and have ultimate power to make the most important decisions. Shareholders elect the board of directors to manage the company and act as agents for the shareholders. When a high-tech startup is formed, the founders are usually issued with common stock and options or warrants to buy further common stock. Employees are hired and they're usually provided with stock options. Stock options do not have voting rights until the options are exercised. So employees ordinarily do not have voting rights to elect directors. When venture capital investors finance a venture, they generally require the company to create preferred stock for the investors. And these preferred stockholders have special rights to elect directors, to veto a sale of the company, and make strategic decisions. The preferred stock is issued with rights to convert to common stock, but this conversion to common usually takes place only at the time of an initial public offering. Where a board of directors is a mandatory requirement of a corporation, the appointment of a board of advisors is not required and is totally at the discretion of the company's shareholders and management. High-tech startups in Silicon Valley and the tech sector often appoint high-profile, respected individuals to a board of advisors. These individuals add credibility to the company, and the individual's agreement to sit on the board of advisors is often seen as an endorsement of the company, its management team and its products. A new startup's website can appear much more credible if it contains impressive biographies of the members of the company's board of advisors. The board of advisors can be compensated with stock options, and cash compensation is not usually necessary. The advisors provide advice, outside perspectives, and valuable introductions to clients, suppliers, potential employees, and a range of useful contacts. The board of advisors reports to the CEO. Where an individual may be reluctant to join a board of directors due to the highly responsible nature of the role and the potential liabilities that could attach, the same is not true of a board of advisors. There are few, if any, fiduciary responsibilities that attach when a person joins a board of advisors, so attracting marquee names to a board of advisors is not usually too difficult. There are a number of professional advisors that are important members of a startup team. Lawyers play an important role guiding startups in Silicon Valley, providing business advice as well as legal representation. The outside lawyer reports to the CEO until such point that the company hires its own general counsel. It's important for startup entrepreneurs to appreciate that the company's lawyer represents the company, not the CEO, the founders, or any individual. Founders and entrepreneurs sometimes hire their own lawyers to represent their own personal interests. Regardless of the size of the company, tax returns must be filed each year, and an accountant plays an important role in preparing the financial reports. Outside accountants often provide advice, guidance, and introductions for startup clients in Silicon Valley. They often introduce Silicon Valley startups to venture investors, for example. Payroll is a specialist job, and this is usually assigned to a specialist payroll firm. When the company starts to generate momentum, investment bankers are often engaged to handle later stage financings as well as potential mergers and acquisitions. It's increasingly popular for Silicon Valley startups to outsource a large portion of their operations. Outsourcing has become popular for high-growth companies wishing to ramp up and grow quickly. Many outsourcing companies offer their services to startups in Silicon Valley as a result. Independent contractors do not have the same rights as employees, so some outsource companies hire staff themselves and make these staff available to startups as independent contractors to the startups. They might be employees of the outsource company, but they're independent contractors for the startups. This outsourcing of the human resource department appeals to small startups looking to keep their core teams small and remain nimble. Outsourcing helps a startup control costs, control long-term commitments, and minimize fixed costs. Where an established employer might find it difficult to reduce headcount and lay off employees, a high-tech startup hiring staff as independent contractors will not be subject to the same concerns. From the company's perspective, engaging staff as an independent contractor can be much more appealing than hiring full-time employees and triggering the employment laws and regulations. However, simply labeling a person as an independent contractor does not always stop that individual being classified as an employee. Workers that were hired as independent contractors have been deemed to be employees by the tax authorities and the courts, so have been found to be eligible for employee benefits and subject to employment regulations. The test as to whether an independent contractor is indeed an independent contractor or is actually an employee looks at the degree of control exerted over the individual by the company. The worker that works from the company's office, uses company tools and equipment, is engaged full-time for the company, and is subject to management control, is usually deemed to be an employee, regardless of whether he was engaged under an independent contractor agreement. On the other hand, part-time staff who use their own PCs, tools and equipment can usually pass as independent contractors.